everybody, welcome back. So I am going to be talking about this court case today, which just cracked me up about how unprepared, and we all know Judge Simpson wants you to come prepared. So they even take a very long break in this because he says he sent a package, but I'm going to tell you, you better come correct when you come in front of Judge Simpson. Here we go.
Case, Group 5 versus Roderick Smith.
And of course, he can't work damn Zoom.
Good afternoon, Your Honor. Robert Weiss, appearing on behalf of Group 5.
Good afternoon, Your Honor. I'm here. For some reason, it's not allowing me to do video, nor can I see anything on the screen.
What do you mean, nor can you see anything on the screen?
I can't see the courtroom or anything. I'm not sure. Am I supposed to, or?
What kind of device are you on, sir?
I'm on a Chromecast, but I also pulled it up on my phone. I can see if it allows me into from my phone.
I see that you're trying to sign in the second time. So
yeah.
That one's kind of just
okay. My phone.
We got you.
Yes, sir.
The one you have to get out.
And then you get all the background noise. Of course you do, because why wouldn't you?
Okay.
A lot of that.
Okay. Yeah,
okay. I think we have it now.
Okay, sorry about that.
All right. So, sir, well, let me ask this. Mr. Weiss, how much is owing in rent?
Okay, as of right now, Your Honor, it's $1,277, which includes, to break it down, rent for the month of November, which is, there's $900 owing for a check that did not clear. There's $197 court costs and 2 late fees of $150, which I think makes up the difference of $1,277.
So when you say 2 late fees of $150, is that $75 a late fee?
Correct, Your Honor.
All right. And sir,
yes. Wait till we get to the part where Judge Simpson is trying to help him get to where he needs to go. This joker isn't even close to prepared.
So basically, Your Honor, my counterclaim is regarding discrimination from the property manager.
Judge Simpson already knows. Look at it. Hands on the head. Hands on the head.
A listing of incidents that's occurred since she's been here. And that's been harassment from the manager.
We got harassment.
If I can kind of revert back to
that discrimination,
what was owed originally,
and what he owes.
So he's manager said that I owe $134.
Saying that because he sent in his check,
showing that the $130.
But then the time frame that it went through, it bounced.
Made allegations that there are, as I read your complaint, that you
attorney's squeaky chair.
That there are 2 things in here that you're indicating constitute some type of racial discrimination.
Judge Simpson already, I think, has a real problem with this.
The other are regarding payments.
Yes. So, if I can, Your Honor, or do you want? Yes. Okay. So one of the incidents regarding towing came from the manager, property manager, she was asking me if I could move my vehicles because I guess other tenants wanted to park closer to their apartment. I called her regional manager, Kurt Herbeck, which actually verified that there was no assigned parking and that the cars were fine. And he also told the property manager that as well.
And so let's assume, hold on, let me stop you. Because let's assume all of that is true.
Yes.
How do you get from that to a racial discrimination claim?
Well, I never said it was a racial discrimination, but it is.
You filed it.
You filed it, baby.
USC.
So there is a form of discrimination that has been that has taken place from the property manager, because after that she had one vehicle towed.
Sir, have you read 42 USC?
Yes, there's various different clauses in there. And
I'm well aware. I used to file claims under 42 USC. So I'm trying to figure out how you make it.
Look at the management girl. She's just sitting there like,
plain.
Sing your piece, baby. Sing your piece. Because you ain't got none.
Well, Your Honor, it wasn't just the vehicle. There were several different incidents that poses discrimination from the property manager, as well as harassment, which is a form of discrimination that a property manager cannot do or constitute upon a tenant. And so that's where the discrimination clause comes from. Is from the multiple different forms of harassment that she's posed upon me. And so that is where I constituted the discrimination.
Right. Detail those out.
Mm-hmm.
Yes. Okay. So the incident, one where there was one where she said rent, determining rent. If it's hand delivered before 12 p.m. on the 5th of the month, she would accept it. I said, okay. Then she told me that we were only allowed to pay rent by the portal, via online. So that
like many of us do.
Said,
if you pay rent, typically
online.
There's a portal.
And I guess it posted on the 5th, and she actually gave me a late payment or a late fee because it posted to their account on the 5th. And I said, well, ma'am, the payment.
Sir, you better keep going because this is not even beginning to be actionable.
Okay, so I'm just trying to go through a description of the incident. The second incident was with the vehicle, that it was towed with no notice at all prior to her harassing me about the vehicles. Her regional manager stated that there was no assigned parking, and he had her tow the vehicle back at her expense.
Okay.
For illegally towing the vehicle. Now, with the rent payment,
so they fixed it.
Herbeck also said that no, we still accept personal checks. So basically, what I'm saying is, by landlord-tenant laws, these are violations.
Here we go.
What landlord-tenant laws are you talking about?
Here we go, y'all.
Michigan compiled laws, John.
Which one?
Section. That's a very large section of laws.
Large.
Correct. Michigan compiled laws contemplate all of the Michigan states.
So which one is it?
Tenant landlord.
Okay, but which one?
That tells me nothing. What's the number?
Second.
He's like, give me a second. Give me a second. I'm Googling. I'm Googling away. Judge Simpson's like, I'm waiting. I wonder what he's thinking right now.
So it's MCL, Your Honor, 554.604. Wait, well, let me It's actually not that.
He's shaking his head
one.
like, bro, you wrong. And he's looking it up. And that's not even close.
I want the section you're trying to refer to.
So what I'm getting, Your Honor, is that it's actually under housing discrimination. I'm not getting the actual code for it. But once I go in under Michigan compiled laws, and it states housing discrimination, it falls under housing discrimination. And these are some of the statutes that aren't allowed.
You're under that rock. You're under it.
I don't know what you just said.
It's nonsensical.
Oh, I'm sorry. I was stating that these are laws that have been constituted.
Which laws are you referring to?
With his watch hanging on his fingers.
Laws, under Michigan compiled laws, it falls under housing discrimination.
What's the section you're referring to?
Okay. So as I look it up, it actually doesn't give me a section or code.
Then what am I supposed to base your claim on?
Yep.
Because you haven't even cited that in your complaint or your counterclaim.
So it falls, Your Honor, under the Michigan Legislature Act 348 of 1972. Michigan landlord tenant laws. And under that statute, it falls under housing discrimination.
In what way?
Basically from increasing rent, special privileges. She also...
Did they increase your rent?
Without your noticing.
Yes, she did, by $200.
But without your notice.
And also...
Without notice to you?
There was notice, but the notice was very short, which didn't give me enough time to even search for another apartment. Pretty much had to accept it because I've been here for nearly 6 years. Not only that, she also told me that once I stated that the problems, the issues with the property manager have become harassment and unbearing, and that I'm not.
You're saying she. Who were you talking about?
Rabia Aslam, Your Honor.
The tea.
She's the property manager for Group 5 Management in Ann Arbor, Michigan. And I sent you.
He's like, I got none of this. I have none of what you're talking about.
Not an affidavit, but an actual signed letter from a witness, which is her own employee that was there in the office when she told me, once I told her that I was feeling that I wasn't getting peace in my residence, she said that I could move, which is also a violation of that Michigan Legislature Act 348 of 1972, which falls under discrimination.
No, it doesn't. I mean, I don't know where you're getting all of this.
Oh my God.
Because I'm just going to be honest with you. What you're telling me is
nonsensical.
Okay.
And he goes, okay.
If all of this is occurring, then explain to me if August 3rd was the date at which the vehicle was towed, which is one of your complaints. Why did you pay September and October rent?
I paid the rent, Your Honor, because it's part of my duty as a tenant. It's my responsibility. So I'm basically just doing what I'm supposed to do on my behalf as a tenant to remain as a resident here in my home. which with the vehicle being towed under MCL statute 257.252K, the Michigan Vehicle Code states that an owner or leaser of private.
You know what? You want to know what?
Yes.
He's so done, y'all.
I don't even know how you're trying to piece this together as self-discrimination.
It's like,
well, Your Honor,
I'm taking all these little bits of things and putting them together because I don't know the law. That would be like me trying to practice law. I don't know.
The discrimination and harassment from the property manager.
Then come correct.
Let me ask you this.
Yes.
Why don't you move?
Well, I'm in a lease.
How long is your lease?
When does your lease expire?
Not until next year, May.
So when did this alleged discrimination begin?
Prior to the property manager coming on, which was maybe around April. I believe she had just recently got hired in here, and it kind of started since then. It's more or less of targeting, and it's like I have no idea what the reason is, what the problem is. That's all I can constitute it as harassment and discrimination. And under the laws, there are stipulations that state certain things can't be performed or actually done by a landlord.
Give me one. And give me the section that prohibits.
He's like, give me something so that I have it.
Everything they've done.
Okay.
And the statute which
they are violating so that you have a little glimmer of hope.
Me that I could move, which falls
under
the MCL Act 348 of 1972. Landlord.
You have got to be kidding me.
So telling you that you can move is discrimination.
I mean, the law
claiming that that's an act of discrimination.
That's what the law stated, Your Honor.
Where? Read it.
What the fuck?
Okay.
He's like, hold on. Telling me to move is discrimination. Yeah. He's like, wait a minute. I gotta look this up. I gotta Google some more. Google it. Gotta love Google. The Google.
Refer to my notes.
Yeah, get out your notes there, boy. Show the notes. Judge Simpson has the patience, y'all. He has the patience. I'd be like, 5 minutes of this, I would have been like, you aren't saying any kind of section of any law. You're just throwing out things. You're not prepared. Let's go. And this is such a slow hearing. Such a slow hearing. And I believe that any lawyer would have, if they had to do this, they would be out.
Section
okay.
You're claiming they have violated.
All right.
He's reading, frantically reading. This goes on for minutes. For minutes, this goes on. Judge Simpson could have ate lunch. Hell, he could have drunk a beer in the meantime, as long as it takes this man. He's just waiting ever so patiently. And he knows the answers to all this. So that's what makes it even more frustrating, I think, than anything, is that he's like, dude, if you're going to make these allegations, make sure that you have looked up the statutes, looked up the under the sections that they fall under, that you think they fall under, because then you're trying. He's knowing that he's trying to do something. This is just complete shit show, ill prepared.
That have to read through to get to where I'm going.
He gonna say something. And Judge Simpson has a ton of cases to see during the day. Like, he's knowing, like, this is cutting into somebody else's time who has their stuff prepared, who has things that, they really need to do. You're wasting the lawyer's time. You're wasting that management woman's time. You're wasting his time. You're wasting all of the court's time. And like I said, any attorney that would do this, they would be out of that courtroom in a heartbeat. I'm not a lawyer, and I even know that. I want one of them big chairs to sit in. Maybe I'll get one Sunday.
Sir, this is the date for trial. You need to be prepared with your allegations.
Yes, well,
I don't have all day. If you're going to accuse...
What did I just say, y'all?
If you're going to accuse people of doing something, then you need to give me not only the factual basis, but the legal basis upon which you're making that claim. And I've yet to hear, quite frankly, the factual basis, even if I take it as true, doesn't sound like it's actionable.
Nope.
But you're not even giving me the legal basis upon which I could even make that finding if I were so inclined to do so.
I understand, Your Honor. I'm looking for it.
I don't think that you understand. Because you tell me that the allegation is she said that she told you could move. And you're saying that somehow and or another that violates some statute. I ask you, what statute are you claiming? And I've been waiting here, and you have given me nothing.
But did send a package, Your Honor, that had
this damn package, y'all.
I actually had inquired.
When did you send a package?
This really pisses off Judge Simpson.
In the Dropbox.
In the Dropbox, the day before the trial. Look at his face.
Did you get a copy, Mr. Weiss?
Nope.
I have not received any copy. Also, if Mr. Smith is claiming
look at him shaking his head.
Discrimination pursuant to 3604 A or B, it's got to be based on race, creed, color, national origin.
I know, and we went through that.
He's got nothing.
I'm very well aware of that, but he says that's not it. He's just saying that, he's under 42 USC, and it quite frankly is verging on a frivolous claim.
Yep.
Of which I think that the landlord's going to be entitled to damages. It's leaning that way because he's giving me nothing. Now he tells me that there's some package in a Dropbox at the court that's delivered late Friday, effectively the day before trial, and I don't have it. You don't have a copy of it.
No, I don't, Your Honor.
Well, I apologize, Your Honor. This is my first time ever having a civil case, and
well, maybe you should have prepared.
Boom.
Because I'm sorry is not enough when you start accusing people of stuff.
You don't take that lightly.
If you're gonna come correct.
Yeah.
Let's just get a brief recess and see if we got something.
So they take a long recess. Long. After a 35-minute break, now we're going to see what Judge Simpson says about everything. But this turkey made him wait 35 minutes because he had to go have staff search for this package of whatever mumbo jumbo he sent in there. And I'm not saying that, he does make some good points. However, if you're going to come to court and accuse people of things, like he said, come correct. It just blows my mind. Anyway, here we go.
The documents that have been dropped off.
Sorry, I got a little heated.
Defendant in this case.
I just think it's ridiculous.
Okay, we scanned it and we are faxing them over, emailing them to you right now.
Okay. Hopefully my emails.
And then this poor guy's got to feed through his emails, figure out where the stuff is, look it over, all while on YouTube and in court. Like, why would you do this?
I'll let you read it and we can talk about it. Thank you.
Okay.
We're going into another recess. Here, I'm going to fast forward a little bit because we just see everybody. So let me kind of fast forward. Look at, dude, we're going over like an hour. Because it takes this guy a while to go ahead and go through it.
I still say, after reviewing it, that it does not raised to the level of discrimination.
Look at him. He's like, no, I know it doesn't.
USC 3604.
We all know this. I know this. I'm not a lawyer.
Mr. Smith, what's your response to that?
Yes, Your Honor. I feel that.
Sorry, it's kind of glitchy. I have bad weather here,
just
so.
Based off of the fact for use of facilities, charging a higher security deposit or offering different terms and conditions, use of the facilities.
Hold on, you have not alleged in
any of that
that they've charged a higher security deposit.
No, so I'm not. I'm more so referring to the use of the facilities with the parking, with the way that I pay my rent, stating that I could only pay online when her regional manager said that they still accept checks. Towing my vehicle with no prior notice are all things of targeting and harassment.
Why did that have to? What proof do you have that had to do with your race, creed, color, or any other suspect?
You got none.
That you may be a part of.
Well, Your Honor, I'm not applying it to race, creed, or color. Basically,
well, hold it. You filed 42. You filed 42 USC.
That was his filing.
Specifically indicated that on the complaint. I got it in
writing
from you.
Oh my gosh.
Yes, Your Honor. To my understanding, that there's also forms of discrimination besides that within the code.
No, you
Yes,
haven't.
I've read it.
Statute. Then not
drink your coffee, brother.
That statute it's very specific in terms of what it applies to.
Correct.
Okay.
You got anything else to say regarding your claim?
He's like, I'm stopping this shit.
Any bit of evidence to me to indicate, even if I take everything you say is true, that somehow or another they have violated the Fair Housing Act in any stretch of the imagination, or that they discriminated against you. Do you have anything else to add?
Yes, Your Honor. Just basically also referring to fair housing, the Fair Housing Center. It states different forms of discrimination under the Fair Housing Act, in which is what I just stated, which would fall under the use of facilities. And I just feel that I've been targeted and harassed based off
what proof do you have that you've been targeted?
I sent the list of the incidents, Your Honor.
I have 2 incidents.
Okay, so they're broken down into 4 separate incidents. One was with the rent payment. The second one was with the vehicle.
No,
Yeah,
the first
yeah.
one.
He's like, you don't even remember what you wrote, bro.
The form of rent. The second one, which was the manager saying that they only accept a form of rent. Then once the rent was paid that way, she still charged me a late payment, which was another incident. And then, of course, the incident where she harassed me with the vehicles, and I actually went up and spoke to the manager about it after speaking with her regional manager, and he stated that the cars were fine, there was no assigned parking, and then the vehicle was towed without any prior notice. So, and that falls under the Michigan Vehicle Code of Michigan Compiled Laws 257.252K. And I just feel that it's been targeting since she's been here, and it's been a form of harassment, Your Honor.
If I can address the towing situation, Your Honor.
Yes, go ahead, please.
The cars were towed initially because they had expired license tabs going back to 2018. There was notification sent on all but one car, which we did in fact return at our own expense to him.
Mm-hmm. So they made that right.
You can't have a car. I think he had 5 vehicles, and
that's a lot in an apartment complex
that are not properly registered. And even after they were registered, allegedly, he used fraudulent tabs.
Uh-oh.
So he's not being targeted because of any violation of 42 USC 3604.
That is how you say it. Here we go. Judge, just lay the hammer.
What do you have to say regarding the amount of rent claimed by the landlord?
So, Your Honor, this entire matter was regarding payment of $134, which you should have bank statements showing that amount had been cashed. Now, she waited, over a month before she processed the rent. She was just holding on to the checks. I sent 3 checks, one in the form of $900, one in the form of $183, which covers the rent. And the other check was $134 for the late payment, which I went agreed. She said, as long as you pay that, you'd be fine. I went ahead and paid it. At first,
what date did you pay that?
Of course, he's got to siphon through everything.
She didn't cash these checks until October. She held the rent checks for a while. I don't know, but somehow,
Mr. Weiss, did she hold the 134 payment?
No, she didn't, Your Honor. Going also back to the $900 payment that he made allegedly on October 3rd, we received it and deposited, I think, on October 4th, and then it bounced. I got records showing that it was deposited on the 4th, the $900. As far as the $183 check, we posted it on the 11th. I'm not sure exactly when it was received, but the $134.
Hold on one second, sir.
Yes, Your Honor.
Are you denying that you owe $900 in rent?
No, sir, Your Honor, I'm not. If I may explain, she had the checks for a certain amount of time. She refused.
He's
to
like,
process
please
the
don't
explain. Actually, I have a
explain.
recording of her saying that I didn't owe a balance. But by the time she processed these checks, she processed them all at once, which because I only had a balance for the rent in there. So the 134 took it over the amount of money that was in the
As soon
account to cover.
As soon as anybody is
October's rent.
talking to you,
So
does this,
I do owe the $900.
it ain't good because you're rambling.
The court costs are just standard court costs in any event. So that's the $197, which counsel claims he's in a trial right now. And then you're saying you don't owe a late fee?
No, Your Honor, I paid the late fee, which was the $134. That was the only rent in question.
What months does Mr. Weiss did the $75 late fees come from?
The late fee is from November of $75 and October of $75 because he still had a balance because the check bounced.
Just because you pay it and it bounces doesn't mean that they're going to be like, oh, okay, your rent is sufficed.
$10.50 in rent and late fees that plaintiff is claiming plus $197 in cost. Is that right?
Yes, that is correct. And the $30 NSF fee. So that should come up to $1277. So it's $900 in rents.
$150 in late fees, $30 NSF fee,
and the court costs, so $197.
Right. Anything else either side wants to say regarding this case?
No, sir.
All right. First of all, with regard to plaintiff's principal claim of the amount of rent that's owed, frankly, and I'm not sure why we're here on that because the defendant has admitted he owes the $900 wrath. There is the late fee of $150, $75 for October, $75 for November, which the defendant owes. And then there is the NSF, which he also admits to. Mm-hmm. So that comes to a total amount of $1,080, which is clearly owed by the defendant. There are $197 in costs. So plaintiff has sustained their burden of showing their claim of the amount of $1,277 total, which is inclusive of cost, which is $1,080 plus the $197. With regard to plaintiff's or defendant's counterclaim, defendant in his initial filing with the court back on October 18th, it was for discrimination, mental anguish, and punitive damages. He's not made any claim for taking those reimbursed for punitive damages.
None.
Nor shown any mental anguish, which would be caused by the plaintiff in this case.
Nope.
His claim for discrimination, in his own document, while he attempts to try to deny it when questioned specifically regarding 42 U.S.C. Section 3604B, which is what he filed, not what is being made up, says refusal to make reasonable accommodations, rules, policies, practices, services, when such accommodations may be necessary to afford such a person equal opportunity to use and enjoy a dwelling. It then flies back and forth. That's what was initially filed. What also is initially filed is he talks about the towing of a vehicle, which the towing of the vehicle has not attached to any of the assessment classifications which would be necessary to file under 42 USC.
He didn't even do it right.
Oh,
good God.
He then makes a statement or claim that when basically brought forth that somehow or another he felt he was being discriminated against, that there's an issue regarding that they told him he could move. Well, that is always
that's your right
to do so if they feel that in their mind that they're not being treated the way that they should be. But that doesn't mean that somebody is
that's not a threat
into some type of discrimination. There is then the issue of the payment, in that supposedly the property manager told him that he needed to pay through a portal. Frankly, that is not uncommon these days, that they would rather you pay through a portal. And
that helps the tenant, that helps the renter. I mean, that's just normal stuff.
Easier way for the landlord to track funds that are paid, as well as, quite frankly, for the tenants to show proof that they haven't been paid. There's a statement, according to the defendant, that's made that that's the way that it should be, that if it's delivered prior to a point in time, there won't be a late fee. But court's understanding, it's very clear from the records that the defendant provided, is that while that was posted, that bounced, basically. It didn't go through. And so the defendant attempts to blame that on supposedly the landlord holding a particular amount, which, because they held it and then sent it through, somehow or another caused the bouncing of that check, and that somehow that's the landlord's fault. It's not the landlord's fault.
No.
It's just like anybody else that has an account, they have to balance it. They have to have the money there. 134 or the 185, the 183 didn't go through.
True.
Because it didn't go through.
Sing it.
Pay it.
Judge Simpson.
Sufficient to cover that, those payments, as well as the payment of the rent. He did. How he intends now to turn that around on the landlord is, quite frankly, beyond me. In terms of,
he's like, what are we going here? Or where are we going?
Bank records. Maybe he should have laid off some of the other things that he decided to purchase during that period of time, and there would have been enough money there that would be like trying to blame either some of these fast food restaurants or the
grocery stores,
Ron Mar, because the check bounced because they cashed a payment that was made. It just simply makes no sense. The defendant, in raising these claims, it is his burden to come forth and show by even a preponderance of the evidence that the plaintiffs had entered into some type of discrimination. There aren't statutes or sections, as indicated by this hearing. When I waited a number of minutes for the defendant to give me the statute section, which he says is violated.
He did. He waited a long time and gave him an opportunity.
Because, quite frankly, there are none.
To at least somewhere come around the ballpark. No lawyer would have been allowed that.
Then provides in the documents that he dropped off late on Friday for today's trial is regarding the towing of or removing of the vehicle without the owner's consent notice requirements. Plaintiffs, quite frankly, admit that one of them may not have had proper notice, and they brought the vehicle back. The other ones, it is undisputed in any type of allegation where they weren't properly tagged, and in that respect, not operational. And so therefore, as with all of the complexes that this court's aware of here in Washington County, those vehicles can be removed. You're required to have your vehicle there, tagged,
everything
and
up to date.
And it's clear in this case, again, not undisputed by the defendant, that they weren't. So even to the extent that he has a claim that they may not have given proper notice, once that's brought to the attention of Group 5, they immediately restored the vehicle to the premises. I don't know how providing two methods as opposed to one by which somebody may tender their rent is in any way discriminatory. It makes no sense to me. Even as I read and read it, they don't have to do it this way, but even if they read the defendant's allegations regarding the parking of the vehicles and what they had indicated, and then what a certain person may have said to him, and then it gets corrected, also doesn't operate toward discrimination. The defendant has just utterly failed to not only allege a complaint of discrimination, but failed also to allege and substantiate any claim of even harassment on the part of the plaintiff. The defendant, did he drop or? No. I'm just going back in.
Boyfriend, like, he can't even stay on the goddamn call.
Mr. Smith apparently dropped. He apparently is now back in the proceeding twice. So
I apologize, Your Honor.
So the bottom line is he's utterly failed to raise any claim either under the Fair Housing Act,
Honey, you lost.
under 42 USC et al. He's just raised no claims that are even cognizable or would be recognizable, and has failed to put forth any proof. Therefore,
his
counterclaim is
dismissed. There's nothing there.
Take under advisement,
so,
given
I just feel like, there are so many people that are so like, well, you did this and you did that, but they never look at themselves for the things that they've done. We all get in a situation because typically we're the ones that get us in that situation. Now, there are times where people, you're doing the right thing. Like, God knows I'm a renter, and I had a time where I had somebody work on my gas fireplace, and the lady was extremely rude. And I remembered every detail of what this woman said to me. Every single detail of what this woman said to me, which was completely uncalled for. I let the management team know for who I rented to, and I also CC'd the regional manager, because I was so like, what the heck? I did nothing to you, and you come to me with an attitude, and technically the company is giving you business. Like, what the hell? And, the regional manager and the management team, they were like, yeah, you're right. Like, no one should talk to anybody that way, and I even thought of it a step further, where I was like, what if I was an old lady and, just had to take this woman's guff? Like, no. So there are real situations like that, but typically you can resolve that, because you've got the ammo behind it. But it's like, these people go out and they're just like, well, I'm going to make a claim because you did this and you did that. That's not how to live life. We all need to lead with love, and, you can agree to disagree, but be kind to each other, and sometimes see it from another person's perspective. Somebody might be having just a bad day or something like that. And hey, if you can't pay rent on time, typically you work things out with the rental company. I've been in really bad spots before, And I can tell you, every time I went with my head down and with humility and been like, look, this is what's going on. I just need a little extra time. I have never been told no in that situation, because, you also approach things differently. So this was just me sharing this because I thought it was really interesting. But, I also love Judge Simpson when he was like, you better come correct. I just loved it. But I hope you all have a fantabulous day. And, it's pretty icky in my area here in Atlanta. So it's a cold day. We finally got some cold weather, but I just wanted to make this video for you guys because I haven't made one in a while. I hope you all have a wonderful day, and just be kind and loving to everyone, everywhere. Like wherever you go, just be that way and lead with love. Be positive, be open. You don't always have to agree. So I hope you guys have a phenomenal day, and I'll see you on the next one. Bye.